Okay, let's talk about Standard 23. Standard 23 has one, two, three, four substandards. We're going to talk about those individually. Let's jump into 23, the STEM, up here at the top. The student will describe and assess the impact of political developments between 1945 and 1970. So it's these political developments we're going to talk about between the years 1945, at the end of World War II, and 1970. Some political developments that occur within the United States. The first one, 23A, says describe the Warren Court and the expansion of individual rights as seen in the Miranda decision. So our focus first will be on the Miranda Court, because you see it says describe the Miranda Court. Okay, so we're going to focus on that. And then it says and the expansion of civil liberty, or expansion of individual rights. I messed up on that because civil liberties is basically the same thing as individual rights. The rights of an individual against infringement or abuse from the government, whether it be state or local or federal government. Civil liberties, individual rights. They are going to expand under the Warren Court. We're going to look at how they do that. And then it says as seen in the Miranda decision. We're going to talk about Miranda versus Arizona that was handed down in 1966. So our elements are the Warren Court. We're going to describe it. Civil liberties, what are those? Are expansion of rights of individuals. And then the case Miranda versus Arizona that is decided in 1966. And theme is judicial activism in the liberal movement and the expansion of civil liberties and individual rights. Okay. This is Earl Warren. And Earl Warren was Chief Justice of the United States Supreme Court. Let's do that. The U.S. Supreme Court. From 1953 to 1969. And while he is on the court as Chief Justice, there's going to be a number of Supreme Court cases that are considered liberal in our U.S. history, because it's going to overturn a tradition of handling things within the United States. So his court, the Warren Court, is considered the most liberal court in U.S. history. And what we mean by the Warren Court, we're talking about this court here. Here he is as Chief Justice of the United States Supreme Court. Okay? And all these men are white men. If you notice here, a recent trend, well, our last two presidents, are to put women on the court, or several presidents, excuse me, to put women on the court and put minorities on the court. But anyway, this is the Warren Court, and this is Earl Warren in the center as Chief Justice of the United States Supreme Court here. Here's a picture of him here. And he is the Chief Justice that handed down, his court handed down Brown versus Board of Education, that reversed Plessy versus Ferguson and said that, you know, segregated schools is inherently unequal and it violates the 14th Amendment Equality Clause. Therefore, it is a violation of civil rights to have African Americans segregated in schools. So it's a civil rights violation. So we see some civil rights expanded as well as civil liberties. But we've talked about this already, how he expanded civil rights for African Americans in schools. And so we're going to talk now about civil liberties and look at what the difference is between civil rights and civil liberties. He also hands down Gideon versus Wainwright, 1963. We're going to look at that. And this one here, Miranda versus Arizona. And these here are actually expansion of civil liberties or individual rights against government abuse. Okay, so these two are examples of civil liberties. Our standards say we have to have Miranda versus Arizona as an example of an expansion of individual rights or civil liberties, but I'm going to throw Gideon in there too because I think it's relevant. I think it's connected to Miranda, and we're going to look at those in a moment. Alright, so Earl Warren gets this reputation while he's on the court as being a liberal, meaning that he goes against the status quo. He doesn't really follow precedent, the way the court has decided things in the past. He kind of deviates from that and makes a decision that he thinks is socially acceptable, and it creates change. And a lot of his A lot of people who didn't like Earl Warren, who were kind of conservative, felt that he was legislating from the bench. The judicial branch is supposed to interpret the law and apply it, not make law. And so judicial activism talks about an activist court that does something that has not been done before through judicial means and creates laws that are really the legislature's job. And so a lot of people criticize him. Some people like him, especially African Americans, say that he helped African Americans. He expanded civil rights for African Americans with his decision, Brown versus Board of Education, by integrating schools and saying you can't segregate them anymore. Now he's going to expand civil liberties. He's going to transform American law. We saw how he did that in Brown versus Board of Education in 1954. Now he's going to do it with civil liberties, or expand the individual rights of those people who are accused by the police of breaking the law, of violating the law. So this is the heart of our standard, is how he expands civil liberties or individual rights and transforms the United States law to show this. And this is his court here called the Warren Court. So if we met the first part of that, which is to describe the Warren Court, okay, now let's talk about the expansion of individual rights. In the state of Arizona here, a man by the name of Ernesto Miranda, this guy here, was accused of kidnapping and raping a woman. And the police brought him in. They had no other evidence, nothing to suggest that he did this crime other than they suspected him of it. And they took him to a room in the police department and interrogated him until he confessed. So he confessed under interrogation. And we've seen in the movies what an interrogation is, you know, where they stick the light in your face and say, where were you at 8 o'clock? You know, where were you at the night before last at 3 o'clock p.m. to 8 o'clock p.m.? What were you doing? Who are you with? Okay. And we've seen these interrogations by the police, and sometimes they surround you and intimidate you until you tell them something. Where constitutionally you don't have to tell them anything at all. You have a right against self-incrimination. You don't have to say anything. And you also have a right to a lawyer to come be present with you while they're asking questions. But there were a lot of accusations that police were beating up people, beating confessions out of the folks, surrounding them, intimidating, threatening them, and then they would eventually tell them what they wanted to hear. Forced confession is what we call it. Alright, so Ernesto Miranda is accused of rape and kidnapping, and he, under interrogation, confesses to the crime. Later on, he gets a lawyer, and he withdraws his confession, saying that, you know, he didn't know he had the right to a lawyer before he said anything, and he didn't know that he had a right to remain silent. In other words, to say nothing at all. Rights against self-incrimination. So he argues that the police should have told him this. They should have informed him of his rights. Well, under the old law, the old guard, the conservative people who felt that, you know, ignorance is no excuse for the law. If you want to know about the Constitution, read it, study it, go to school and learn about it. You know, the police's job is not to inform you of your rights and teach you what the Constitution says. That's your responsibility. However, the Supreme Court is going to look at that differently. And they're going to say that, you know, what do we do about these police who are interrogating these suspects accused of crimes that they beat or intimidate a confession out of? What is the penalty to police officers that do this? Was this done to Ernesto Miranda? Okay. And does Ernesto Miranda need a new trial with his confession taken out? Alright, and so that's the question. And, you know, he says this: I didn't know I had a right to a lawyer first, and I didn't know that I didn't have to answer any questions while being interrogated. They should have told me these things. So he argued that he had not been informed of those constitutional rights to remain silent or have a lawyer, and he felt like they should have. In other words, he felt like his civil liberties, since he was accused of a crime, had been violated. And what are civil liberties? Let's look at the definition of that real quick. Civil liberties are protections for individuals accused of crimes or anything, are against abusive government actions, is what they are. Individual rights, individual protections that are usually located in the Bill of Rights. And these are for individuals, if you see that. These individual rights are protections against abuse of government. Some characteristics are like the school cannot, or these are examples actually, school cannot tell you what your religion is or what you can believe, and the government cannot put you in jail without a trial by jury. Some of these examples are the 5th and 6th Amendment, accused of crimes. This one's the 4th. Here's the 4th right here, rights against unreasonable searches and seizures. And the 5th is due process of law, and the 6th is a lawyer. Rights against self-incrimination is the 5th. Some non-examples are you have a right to be rich, or you have a right to be treated special in some way, or if you're a police officer you have a right to beat up people because you have the power. That's not acceptable. So civil liberties are these individual rights against abuse of government. And Ernesto Miranda said his had been violated because the government didn't inform him of his right to remain silent and to have a lawyer present. And the Supreme Court is going to make a decision on this, but let's look further at the civil rights and civil liberties. Generally, civil liberties that we're talking about right now, they're going to be expanded under the Warren Court, generally come from the Bill of Rights. They come from the Constitution and other places, but generally, and in this example, the Bill of Rights, the first 10 amendments to the United States Constitution. And civil rights actually come from the Equality Clause of the 14th Amendment that we talked about. And we got the 14th Amendment through the Reconstruction Amendments, and it was really meant to help African Americans against state infringements on their rights. But it's expanded, it's going to be used for everyone, but civil rights are equality issues. I'll give you an example. Okay, so a civil liberty, for an example, would be Socialist Eugene Debs. A lot of people felt that his civil liberties had been violated because he has a First Amendment right to free speech. That he should have been able to say whatever he wanted to say. The government should not have been able to lock him in jail. But unfortunately for him, the Supreme Court feels like when we're in war, we can suppress individual rights. But any other time, he would have been okay. He would have been protected. But we look back on this and say, you know, all he was doing is exercising his free speech. He knew that too. But they arrested him, put him in jail. He spent about 2.5, 3 years in there. But a lot of people to this day believe that Eugene Debs had political views different than everyone else's, was thrown in jail simply because he exercised his free speech or civil liberty. So people felt his civil liberties had been violated. Example of civil rights down here was when we saw where Homer Plessy in Plessy versus Ferguson case in 1896 was made to sit on a separate train because he was 1/8 African American, what they called back at that time an octoroon. But Jim Crow segregation laws that segregated the races are considered since the civil rights movement are a denial of equal protection of the law or equal treatment under the law, a violation of the 14th Amendment Equality Clause, and therefore are considered civil rights. So those are two examples. And under the Warren Court, what laid a foundation for Ernesto Miranda's decision was Gideon versus Wainwright. In Gideon versus Wainwright, Clarence Earl Gideon asked for a lawyer, and he was an indigent suspect or indigent defendant. In other words, he was poor, he didn't have money, he was in poverty, he couldn't afford to pay for a lawyer. And he said that after he was found guilty and sent to prison and stayed in there about 5 years, he argued that he had a right to a lawyer under the 6th Amendment, and he asked for one before he went to court, and it was denied one by the state of Florida. And the Supreme Court under the Warren Court agreed with him and actually ordered a retrial, and he was actually released from prison. So poor people suspected of crimes and tried in court must be provided a lawyer if they can afford one. So this lays the foundation for Ernesto Miranda. It shows that Earl Warren is going to protect people accused of crimes. In other words, he is going to protect their individual rights against the government. their civil liberties against the government. So the court found in 1963 that Clarence Earl Gideon, his civil liberties had been violated because the Sixth Amendment was not followed. And it says this in the Sixth Amendment: in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. In other words, a right to a lawyer. And since the state of Florida did not give a lawyer to Clarence Earl Gideon, then they violated his civil liberties. And remember that we said civil liberties come from the first 10 amendments. So this civil liberty in question here with Gideon versus Wainwright was a Sixth Amendment violation, civil rights violation, or individual rights violation to have a lawyer, and he was not given one. Okay, so with Ernesto Miranda, his lawyer and he were arguing that his civil liberties had been violated since the Fifth and Sixth Amendments were not exercised as his individual rights against the police. He and his lawyer argued that he had a right against self-incrimination. They didn't tell him he had this right to just get up and walk out. He didn't have to say anything at all, and that they should have told him he had a right to a lawyer. He didn't have to say anything unless a lawyer is present. So the old group says, he should have learned this in school. He should have read the Constitution. It's not the police's job to be out here teaching these criminal suspects. They're supposed to catch them in crimes and take them to court, lock them up, and take them to court. But the court, the Supreme Court of the United States, looks at it as he has a Sixth Amendment right, his civil liberty or individual right, to a lawyer. He should have been provided one, and he should have been told he had a right to one. And then in the Fifth Amendment, his individual right or civil liberty against rights against self-incrimination. He didn't have to tell on himself, so he really didn't have to answer the police's question. But since they intimidated him, surrounded him, he answered them anyway and gave a confession, what would be considered coerced or forced. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, property, or due process of law. And due process of law is the right to have an attorney, and rights against self-incrimination here is what we call this, to be a witness against yourself. That's what we call it. But anyway, in a 5-4 split vote, with Warren here as the head, as Chief Justice, and him giving the majority of the court, 5, they voted that yes, his individual rights or civil liberties to be informed of his right to a lawyer and his rights against self-incrimination, the police should have read those to him. So as a result, this changes. We said that he was going to transform, Warren was going to transform American law in the United States. Well, how does this transform American law? And how does it expand these civil liberties of people accused of crime? Before Arizona became an issue, in every state in the United States, no police officer was made to read rights and inform people suspected of crimes before they interrogated. The key is before they interrogated them and asked them questions about the crimes. So this is going to transform American law, because after this decision, every police officer in every state, before they interrogate a suspect that's under arrest, has to read them their what's called the Miranda rights or Miranda warnings. We're going to look at this in just a few minutes. So police officers now, before they interrogate, must read to people arrested prior to their questioning that you have a right to remain silent. You have a right against self-incrimination, in other words. So what started out as an issue in Arizona, and before that they didn't have to do this, ends up with police officers in every state having to read these Miranda warnings. And so the Supreme Court establishes a new law for every state. That's what's called judicial activism. They created this law that police officers in every state must abide by. The state legislatures didn't make this rule. United States Congress didn't make this rule. The Supreme Court did. And see, a lot of people criticize this and say it's judicial activism. It's a bad thing because the Supreme Court's not supposed to make the law. It's supposed to interpret the law. And the legislature is supposed to
make the law. But at any rate, the Supreme Court established the principle that all criminal suspects must be advised of their rights, individual rights, or civil liberties before being interrogated. These became known as Miranda rights right here. And here they are right here, Miranda warnings or rights. And I got it here. You guys watched this in the movies before. You have the right to remain silent. Anything you say and do will be used against you in a court of law. You have a right to a lawyer and have him present with you while you're being questioned. Here, the police officer says, hey, you have a right to remain silent. That's in the Fifth Amendment, the rights against self-incrimination. And here you have a right to a lawyer. That's in the Sixth Amendment. We looked at those already. So Fifth Amendment against self-incrimination. Sixth Amendment, you have a right to a lawyer. And I've highlighted those for you. If you cannot afford to hire a lawyer, one would be appointed to represent you before any questioning if you wish. So when we get that, actually the police having to provide a lawyer from this previous case, Gideon versus Wainwright, where the court said you had to give poor people a lawyer if they didn't have money to have one. And then you can decide at any time to exercise these rights and not answer any questions or make any statement. So, Ernesto Miranda, he gets his individual rights protected by the court. Actually, he's sent back to a retrial. He's actually found guilty without his without his confession that he gave to the police while being interrogated. He is actually sent back to court, and they find him guilty and send him to jail. And he stays in jail till the 1970s. Then he gets out and he's released. But at any rate, we see here that the decision of the court is going to expand the rights of individuals, especially those individuals who are accused of crimes. So I think we've met our objective. Let's look and see if we have. Okay, did we talk about the Warren Court? Yes, we did. We talked about Earl Warren as Chief Justice, his court, and how they made these decisions. We talked about civil liberties such as the Fifth and Sixth Amendment, right to a lawyer, rights against self-incrimination, and how those individual rights and civil liberties had been expanded by this court, because before this time police didn't have to read rights. And then we talked about the Miranda versus Arizona case. If you have any questions, ask them in class. Good luck on the quiz test, EOCT.